And Mr. Valdez and Ms. Tanaka, I see you in the virtual courtroom. We are ready to proceed. So Mr. Valdez, go ahead.
Thank you, Your Honor. May it please the court. My name is Tom Valdez and I represent the appellant Osprey Healthcare Center in this case. Your Honors, we're here today to ask this court to reverse the circuit court's decision which accepted plaintiff's contrived argument regarding the purported invalidity of the durable power of attorney at issue in this case, and reverse its decision based on the acceptance of that position to deny Osprey Healthcare Center's motion to compel arbitration as a matter of law, as a matter of equity, as a matter of policy. Plaintiff's argument, which the trial court improvidently accepted, is based on the somewhat incredible claim of Sharon Outwater, who is the attorney in fact under the power of attorney and the daughter of Mr. Pescazzi, that she orchestrated her father's execution of the power of attorney with two witnesses present, had him sign it, had it notarized, although she, but nobody else, knew that he lacked capacity to execute the power of attorney at that time.
Mr. Valdez, let me ask you a question. The issue that is before us today, I understand your position that Ms. Outwater may have engaged in some misconduct, but is that the key issue for today, or is the key issue whether or not Mr. Pescazzi was competent, had the wherewithal to knowingly, voluntarily execute the power of attorney?
No, Your Honor, that's not the issue. The issue is whether the power of attorney that was presented to the facility by Ms. Outwater and accepted by the facility in good faith reliance, based on the controlling statute, section 709.2119, was a power of attorney that they could reasonably rely on as allowed by the statute. Based on the statute,
whether he lacked capacity or not, your position is that's irrelevant?
It is irrelevant, Your Honor, where the statute says that a third person who in good faith accepts a power of attorney that appears to be executed in the manner required by law at the time of its execution may rely upon the power of attorney and the actions of the agent which are reasonably within the scope of the agent's authority. That's what happened here. Osprey was presented with a durable power of attorney that appeared to be executed in the manner required by law. I mean, none of us here would look at this power of attorney and think it was anything other than a facially valid power of attorney. So under the statute, my client was entitled, based on that fact, to rely upon the durable power of attorney. There's a presumption of validity there. They have a right.
Isn't that a rebuttable presumption? Because that is a legal document binding a patient to arbitration. Are you saying that that patient then does not have legal recourse to challenge the validity? That your client can simply accept it because it appears on its face to be valid and the discussion is over?
Your Honor, the discussion is over under the statute only if the entity, in this case, my client, accepts the power of attorney when it, though it knows, in the language of the statute, it says a third party does not accept a power of attorney in good faith if the third person has noticed that the power of attorney is void, invalid, or terminated. And it goes on from there. My client had no notice that this power of attorney was allegedly void, invalid, or terminated at the time that Ms. Atwater presented it, at the time that they accepted it, and the time that she used it to act on behalf of her father. It wasn't until years later in this litigation that she first raised the issue of the invalidity of the power of attorney. So,
Mr. Valdez, remind me, where did your client present evidence that there was reliance on the power of attorney?
That was presented, Your Honor, in the testimony of the former executive director, Kelly O'Sullivan.
I thought she said that, in fact, she didn't really look at it. She accepted the papers that were signed, and that was it.
No, that's what appellee states in their brief. But if you look at the actual record sites, well, there are two of them that are important. The one they cite to in their brief, when you look at it in the record, is the following question and answer.
Why don't you tell us what page on the transcript that is?
That is Kelly O'Sullivan's transcript, page 18, line 22 through 25. Plaintiff's counsel asked, did you have anyone who reviewed the powers of attorney to determine whether or not it gave authority necessary to sign the paperwork? And she says no. So what she's saying there is they don't have a specific person designated to review powers of attorney to determine their validity. They don't have an attorney on site. They don't have anything like that. But earlier in her testimony, she testifies, and this is on page 10 and page 11 of her testimony. She's asked on page 10, line 21, if the new resident had a history of dementia or difficulty in making their own decisions on their own, is there anything that you would do with respect to determining who's going to complete the paperwork? And she answers, page 11, lines 5 and 6, okay, the POA would have been presented as their power of attorney, which is obviously using the term power of attorney the way it's used colloquially, but the POA would have been presented to establish that their attorney, in fact, had authority to act on their behalf. Is pretty clearly what she's saying. She's not a lawyer. She testified to that. But she's saying this is their practice. Their practice when somebody is incompetent is to look to somebody that is an attorney in fact, or what they were calling a POA, under a durable power of attorney. That's exactly what they did here.
Isn't her acknowledgement essentially that no one, including her, actually reviews the power of attorney?
I don't read it that way at all, Your Honor.
I don't. What you're reading to us, which is from the transcript, doesn't say that, yes, we look at it to make sure it's been properly notarized, the witnesses are independent, authorized witnesses, and so forth. My sense of it was, I read the transcript, is that no one actually reviews the documents to make certain that they are adequate to establish that the patient gave the power of attorney.
Your Honor, if the statute does not require the facility or anyone else that relies in good faith on the power of attorney to look into the qualifications of the witnesses,
the statute gives a remedy for essentially misconduct in presenting an invalid power of attorney, which is to recover damages that are incurred in reasonable reliance, which seems to me those are the damages that you might have a cause of action for against Ms. Outwater. But how does that establish that the decedent gives up the rights that he has to a jury trial, to not have to go through arbitration and so forth?
Well, Your Honor, two things. First, we argued in our brief that there was never any proof at any point while Mr. Piscazzi was alive that he lacked the capacity to contract, or that despite any confusion, he couldn't have executed this in a lucid moment. And we talked about
Dr. Bloomfield's testimony appears to be pretty clear that as of December 14, he was diagnosed with dementia that could not be improved with any medical intervention at all. It was going to deteriorate.
Well,
and that he did not understand the durable power of attorney by virtue of his scribbly marks, wrong initials and everything. You didn't have an expert to rebut that.
Because the doctor testified these issues based on a review of paper. Well, after
we allow that all the time. We allow IMEs all the time to do that.
Well, but he didn't. In an IME, you examine.
Not all the time. They just review records. This is a neurosurgeon.
It is a neurosurgeon, but he wasn't present that day, and none of the people. The statute doesn't require an expert finding of capacity. All it requires, the durable power of attorney requires, is that you're presented with a document, a power of attorney that appears valid on its face, which this one does. And getting back to my point for a second, I was just saying as an initial matter, nobody ever opined that Mr. Piscazzi lacked the capacity to enter this agreement until this litigation started. Then plaintiff asserted this position. Then they got Dr. Bloomfield. Nobody asserted that at the time that this was signed, and there are witnesses that were present that obviously raised no objection to that. Now, it doesn't say in the statute we have to go back and find those witnesses or that notary. The statute, the statute is meant to promote the use of durable powers of attorney as a cost and time effective alternative to formal guardianship. And as a result, the legislature, when they rewrote the durable power of attorney statute a few years ago, made it very clear in 709.2119 that people or entities like my client could rely upon powers of attorney like the one at issue here. They accepted it. It says a person who accepts, in good faith, accepts the power of attorney that appears to be executed in the manner required by law. My client accepted the power of attorney.
What testimony do you have that this man executed it in the manner required by law at the time of its execution?
Your Honor, I don't think that's what the statute requires.
That's exactly what it says. I'm reading it.
Your Honor, it does not. The statute does not say, with due respect, the statute doesn't say that we must put on evidence of that individual's capacity before we rely on this. They brought up capacity after.
Don't interrupt me. It says the power of attorney that appears to be executed in a manner required by law at the time of its execution. Ms. O'Sullivan testified, I've never faced a situation like that, if you read further on page 12 of her deposition.
Your Honor, I apologize for interrupting. I think it just got carried over there.
He was asked about receiving a patient with dementia who presents the power of attorney. She goes, I've never been presented with that. I don't know.
Well, Your Honor, she testified earlier that what she would have done in that situation was to rely on a power of attorney. And this power of attorney, the point I'm making is that the question of capacity is not one that the facility or a bank or the IRS, which Ms. Outwater used this document to file Mr. Piscazzi's taxes with. It doesn't say that those entities have to go back and look at the person's capacity. They have no way of doing that. All they have is this document. And so the law says that here are the circumstances under which you may rely upon this document. And I honestly would ask anyone here, can anyone here honestly say when they look at that document that it does not appear to be a valid power of attorney? It's a disingenuous argument by appellees to present this document, which appears on its face to be a valid document. The evidence is the facility did accept it. It was included in their records along with the admission agreement, and they allowed Ms. Outwater to act in compliance with it. And so under the statute, the exception, the remedy for appellee, if they had an issue with this, would have been to point out, hey, they had noticed at the time that they accepted this. They had noticed that this was invalid. They haven't put forth a shred of evidence to suggest we had noticed that this was invalid or that this gentleman was incapacitated. He executed this power of attorney before he ever came to the Osprey.
Your client wouldn't have had notice anyway, because the witness testified that nobody really looks at this, right?
No, she testified. She testified.
Did you all have anyone who reviewed powers of attorney to determine whether or not it gave the authority necessary to sign paperwork? What was the answer, Mr. Valdez?
She said no, Your Honor, and I don't think they had a specific person that was.
So there was no. Your position is that even though there was no one who reviewed the power of attorney to determine whether it appeared to be executed in the manner required by law, that doesn't matter. That if somehow, sometimes somebody says, well, it looks good, 3 years later, that's enough for your client to have relied on it, despite the fact it didn't rely on it because nobody reviewed it.
Your Honor, respectfully, I read her testimony on that point differently. I think she was asked a pointed question as to whether there was anyone at the facility that was specifically designated to do this, and there was.
She doesn't say that she reviewed it, right?
She wasn't specifically asked that question, but she accepted it.
Mr. Valdez, your position is that your facility had the right to rely on this document and that it reasonably did so, right?
Yes, Your Honor.
Okay. Tell me where your client established that it reasonably relied on a document despite it not having reviewed it or no one having reviewed it.
Your Honor, I don't think the record establishes that they didn't review it.
And there were, on the face of the document, there are some oddities. Do you agree with that?
I don't think there are. I don't think there's anything to question that would cause anyone to question the validity of the document.
The fact that Mr. Pescazzi could not spell his name correctly, the fact that he initials the document in different places with different initials that don't seem to make sense.
Well, Your Honor, it's a person who's in.
Would a person who have reviewed that document possibly have noticed that? Wait a second, this doesn't seem right.
Your Honor, that's a possibility that someone may have looked at that and come to that conclusion, but I don't think that rises to the level of notice of the invalidity or notice of invalidity of the document as that's defined in 709-2119.
So do you have any case law that, I mean, the bottom line is there any case law that you can point us to that says a third party can take a piece of paper, stick it in a file, never look at it, and that is sufficient for them to establish it appears to be executed in the manner required by law?
Your Honor, I have no case that relies for that. There's also the proposition that you just stated. But I think that
you didn't ask to reserve time. You're at 2 minutes. Do you want to reserve the rest of that?
I'll reserve the rest for rebuttal, Your Honor.
Very good. Ms. Tanaka.
Thank you, Your Honor. Lisa Tanaka for the appellee, the estate of Ronald Pescazzi. May it please the court. Your Honors, I want to just start off by reminding the court that the trial court's factual findings with regards to incapacity and lack of reliance are presumptively correct. And unless this court finds that they are clearly erroneous because there's a complete lack of substantial evidence, those findings cannot be disturbed. In other words, we're not here to reweigh the evidence.
Ms. Tanaka, I'm not sure that is really an issue that's in dispute for today. I think the question that, at least for me, that I'm concerned about is the statutory language regarding the power of attorney that appears to be executed in the manner required by law at the time of its execution. This document had 2 witnesses. The document had a notary public. Nobody called either of the witnesses. Nobody called the notary public. So on its face, you heard the question that I asked Mr. Valdez, is there any authority for the proposition that a document such as the power of attorney, which on its face has 2 witnesses, has a notary, that the facility can't just take it and stick it in the file? Do they have an obligation to actually review it?
Absolutely, they do, Your Honor. And I'll point to the Stolley case, which is actually out of this court. Judge Silverman, it was one of your cases from 2010. And the reason I point to this case is this case was actually, the analysis done by this court was based on apparent authority, which the statute 709.2119, really the requirements of the statute are the same as apparent authority. The statute, the requirements of the statute requires that a third person accepts a power of attorney, relies on the power of attorney in good faith, and does not have any notice or reason to know of its invalidity. And that really mirrors apparent agency. And that longstanding principle requires that there be a representation by the principal, that the third party rely on that representation and change their position based on that reliance. And what this court in the Stolley case reiterated is that the actions of a purported agent alone are insufficient to create an agency relationship. And that applies here because, as Your Honor pointed out, there's no evidence that supports the requirements under the statute. The very first requirement that I think was overlooked in the discussion with opposing counsel is the first requirement is that a third person accepts the power of attorney. And there is nowhere in the record that the appellants accepted the power of attorney at or before the time that Mr. Piscazzi's daughter signed the arbitration agreement. The appellants state that it was offered to them, but Ms. O'Sullivan doesn't state that. The executive director of the facility, she just states that what she may have done, possibly could have done. And in fact, the part of the testimony that was pointed out.
I'm honestly having a hard time accepting that argument. I mean, there was a packet that Ms. Sullivan provided that was signed by Ms. Outwater. There's apparently been, to my recollection, no argument that the power of attorney was not part of that package. Is there any evidence that suggests it wasn't part of that package?
Well, the packet was actually the admission paperwork. And Your Honor is correct that in that packet, it does, you know, there is written in that Ms. Outwater is the power of attorney. In fact, Ms. Outwater actually testified it was her understanding that she was signing as the power of attorney. But that, of course, is insufficient just based on Ms. Outwater's actions. So even if the power of attorney was accepted by the facility at or before the time that the arbitration agreement was signed, there's no reliance and there's no good faith reliance.
Well, let me ask you this question, because I want to get to the meat of the matter. Let's just assume, and Mr. Valdez may not believe me, but I have some sympathy for him because the facility accepts this. It appears on its face to have some sort of legal significance to it, whether they read it or not. Let's just put that aside. Let's just assume that 709 applies. But the case law clearly says that the plaintiff can still challenge the validity of the arbitration agreement under contract principles. So still, you can still challenge this on capacity, can you not? I don't see where 709 is determinative, where it precludes a court doing the contract analysis that was done in John Knox, which relied on Gilmore out of the Middle District. So I think Mr. Valdez seems to believe that if he relies under 709, there is no legal recourse. It's a done deal. You're going to arbitration. Is that true?
That is not true, Your Honor. And in fact, I'll except for the purposes of this discussion, that if the appellants had accepted the power of attorney, if they had in good faith relied upon it, if they did not have notice at the time that they accepted it, then here we are now. Can they, as Your Honor asked, can they now just rely on this power of attorney? The answer is no. And the part that hasn't been addressed is 709.2119 has two relevant parts of it for this case. The first portion is under section 1, which the appellant cite to that says that if they rely in good faith without notice of its invalidity, then they can enforce obligations. But what happens is once a third party knows that the power of attorney is invalid, such as we have here, even during this litigation, then Section 5 of the statute comes into place. And what the Section 5 states is once there is notice that the power of attorney is not valid, then the statute only protects third persons who accepted under good faith reliance with no notice at the time. The statute protects them from losses and liabilities. They can no longer enforce obligations, which makes sense. It falls squarely with the case law. It is in line with public policy that doesn't allow a third party to knowingly use an invalid power of attorney against an unknowing innocent principal. And it also falls squarely within the longstanding principle of apparent authority. And in Florida, while Florida favors arbitration, that of course presupposes that there's a valid arbitration agreement. And the Florida Supreme Court has made clear that forcing one to arbitrate when they have not agreed to do so does not square with principles of justice and equity.
Well, you know, another public policy that seems evident to me from the statute is that people should be able to avail themselves to durable powers of attorney. It's beneficial to all parties involved. The statute provides protection for people who accept it, and it also provides a penalty if it's wrongfully refused. And I know you addressed that briefly. What would have been the basis for Osprey to reject this power of attorney at the time that it was presented?
So the Power of Attorney Act under 709.2120 Section 4 provides a list of different reasons that a third person does not have to accept a power of attorney or can reject it. And I think two of those—
So just in this specific, I mean, I've read the statute, but I'd like to know in this specific case, when this was presented, what would have been the basis for it to be rejected?
So there's two bases. For the first basis that it could have been rejected would be under 4 subsection A, where a third person is not required to engage in the transaction with the principal. There's no requirement, rule, statute, or law that requires an assisted living facility to enter into an arbitration agreement with its residents. So
or even an admission agreement, right? If they rejected the power of attorney for the purposes of the arbitration agreement, they could have rejected, like, no, you can't sign that, and you can't sign the admission agreement. We don't accept it. And we're not accepting, you know, we're not going to accept this, and, you know, look elsewhere, right?
And certainly they could have, except that with the admission agreement, that's a different analysis, because there are statutes that would allow a healthcare proxy to be designated or a guardianship to be put into place such that healthcare decisions could have been made for Mr. Piscazzi and the admission agreement could have been signed. The arbitration agreement, not being a healthcare decision, is a separate analysis. But the second reason that they could have rejected the power of attorney is under Section 4, subsection E. And it says that a third person can reject it if there's a good faith belief it's invalid. And while the appellants argue that they had no notice it was invalid, the arbitration agreement was signed at the time Mr. Piscazzi was being admitted to their facility, an assisted living facility. It's a healthcare provider. And in fact, Ms. O'Sullivan, the executive director, testified that they have a duty to ensure that these residents are coming into their facility appropriately. In other words, they can care for these residents. They have an obligation to—
No, I understand that, but I'm trying to look at this from the perspective of, you know, you have a statute that really encourages the use of these and discourages an arbitrary rejection. And it's not just going to— I mean, these durable powers of attorney are used in a variety of contexts, obviously. So you go to the bank. The bank, before they let you open an account or transact business, has to have like a mini, trial on whether this person was competent at the time they did the DPOA. Like, and the attorney, in fact, every time they go to use this, has to somehow prove that, oh yeah, when he signed this, he was competent. I mean, isn't that sort of the upshot of your argument?
I don't think that is a blanket case, Your Honor. I believe that it's a different situation where it's a healthcare provider that has an obligation to know the health.
The statute does not distinguish between who the power of attorney is being presented to.
Correct.
It says you are entitled to rely on it.
And I agree with that.
And if you want to reject it, you have to meet these criteria.
Correct. And it doesn't
say, when it says to rely on it, it doesn't, I don't read anything in this statute that suggests you have to make an independent determination that the person was competent at the time they entered into the durable power of attorney.
And I would agree with Your Honor, except that if the third person does have notice that it's invalid, then that's a different analysis.
What's the notice? What would have been the notice here that at the time they did this power of attorney, he didn't have the competency to do it? Well,
as their executive director testified, they have a duty to know the medical needs of and history of their residents.
No, that's not my question. What would have put the facility on notice when this was presented to them that at the time it was entered into, he lacked the capacity to do so? What would have put them on notice?
Well, the first thing would have been that Mr. Piscazzi was being admitted into the dementia lockdown unit. And so knowing that Mr. Piscazzi lacked the capacity at the time,
which is why he needed a durable power of attorney,
Correct, but the power of attorney was signed by him.
So, that's a real catch-22.
Well, the power of attorney was only signed a couple months earlier. And so you're right, he needed a power of attorney. He needs someone to act from, but that's not, a power of attorney is not the correct vehicle. In fact, it's not permitted to be executed once somebody has lacked capacity. The correct vehicles at that point would have been a guardianship, or if the facility needs somebody just to make healthcare decisions for Mr. Piscazzi, Florida law and the statutes allow for a healthcare proxy to be appointed.
Well, so what you're advocating then is going to keep a lot of people probably from being able to get admitted into to facilities like this, because the facility is not going to be able to rely on a power of attorney. And they probably don't have the wherewithal to go back in time and determine the capacity of an individual at the time they entered into a power of attorney.
Well, I don't think that, twofold to that, I don't think that they have to go back into the beginning of time. I think when they have noticed that, and as it was also pointed out, the face of this document also calls into question Mr. Piscazzi's capacity. He spelt his name wrong. He put letters next to where he was supposed to initial that weren't actually his initials. All of this information that the facility would have had, they should have looked, and they either knew or should have known that Mr. Piscazzi had lacked capacity for longer than the instant he was being admitted.
So their answer should have been, no, thank you. Please go elsewhere. We're not going to admit this gentleman.
The arbitration agreement is not required necessarily.
No, but an admission agreement goes along with this, and agreements to make payments, and there's more than just the arbitration agreement.
Correct.
They're not going to accept it for one purpose. They're not going to accept it for any.
Because
the next thing you know, you're going to be challenging something in the admission agreement.
I agree with Your Honor completely. They can't accept the power of attorney for anything. But they do have options as far as having admission paperwork. In other words, a decision for healthcare purposes for Mr. Piscazzi. And actually, in the Mendez case out of the Florida Supreme Court from 2016, the court does state that, and I quote, "If the facility was concerned that a resident lacked the required mental capacity to execute binding contracts, it could have availed itself to the legislator's comprehensive statutory scheme governing incapacitated individuals." And the court referred to the guardianship statute. So
right. So then you take the person who's gone to the trouble to get the power of attorney and who's been using it and tell them go to guardianship court. Wish you well. How does that serve the interests of people in this situation?
Well, it absolutely serves the interests of Mr. Piscazzi because he never agreed to the power of attorney. He never granted authority. He didn't have the capacity to do that. And so, and that's, I think, what especially the trial court pointed out, what we're looking at here, especially with this arbitration agreement, we're not looking at Miss Outwater's rights. We're looking at Mr. Piscazzi's constitutional rights, and he never agreed to arbitration. He never agreed to waive that, and he never agreed to give anybody else the authority to waive those rights. So this actually does protect the principle.
So if he had a guardian, the guardian could waive it, right?
Potentially.
Right?
A guardian.
So he still wouldn't have done it, but his guardian could do it for him. But, you know, that's better than the durable power of attorney, the attorney, in fact, doing it for him.
A power of attorney is a contract. And if he's not, if he's I
mean, people do this for a reason. People enter into these types of durable powers attorney for this very reason, because they anticipate that at some point, an individual is not going to be able to take care of their business for themselves. And they do this, and it's in lieu of a guardianship for the very reason that they, you know, it saves them the cost and complications involved in having a guardianship. This is an alternative to make it easier for people.
Absolutely.
How does your argument advance that policy?
I agree with that completely, Your Honor. A power of attorney, in fact, on top of all that, it allows an individual to choose who their agent will be, opposed to a guardianship. They don't get a choice. But the problem with that is, in this case, Mr. Piscazzi did not make that choice. He did not enter that power of attorney. He did not choose to enter that power of attorney. And a power of attorney cannot, like any other contract, cannot be entered. It cannot be executed as valid if the individual lacks the capacity to understand the nature and transaction, or the nature and effect of that transaction, which is what we have here. So while a power of attorney is easier, it does allow a lot more flexibility. The principal can determine in the power of attorney what authority they may or may not want to grant to their agents. That's not what happens here. Mr. Piscazzi did not have the capacity to understand it, and so he did not enter it. But I also wanted to address, Your Honor was asking with regards to, was the appellants, was the facility, were their hands tied with this? No, the appellants are not tied to, well, we have no recourse. The statute, as I mentioned, under subsection 5, does protect the facility from any actions that they may have done if they had reasonably relied in good faith on the power of attorney without notice that it was invalid. So if all of those had been met, section 5 still offers protection to the third party. However, once they know that the power of attorney is invalid, that protection just is against any losses suffered or liabilities incurred. It doesn't allow them to continue to try to enforce obligations against a principal who is unknowing and innocent and never entered into that power of attorney agreement.
Ms. Tanaka, take about 15 seconds to wrap up.
Thank you, Your Honor. So the record, I know that the issue really in this discussion wasn't whether Mr. Piscazzi was of capacity or not. I think that the record and our brief is clear based on the evidence that supports that. And so for these reasons, and because there is a lack of evidence to support any reliance under either apparent authority or the statute, we'd ask that this court affirm the trial court's decision and find that the arbitration agreement is unenforceable. Thank you.
Okay, thank you very much. And Mr. Valdez, you have just over 2 minutes to reply.
Thank you, Your Honor. As a preliminary matter, I'd like to address a point Ms. Tanaka made and point out to the court that the trial court decided this on paper only. There were no live witnesses at this hearing. But moving on to the meat of things, and to Judge Sleet's point in the case law he talked about, if Osprey had Mr. Pascazzi attempted to have him sign or had him sign the arbitration agreement in this case, then his capacity would be at issue here, because they would have been in a position where they had to make some kind of assessment. They're looking at him. They've got now medical record. They're looking at him as he sits there today, and they have to make a determination whether, in their view, he has the capacity to execute these documents. That's what the case is.
So if we reverse this case, how do we deal with the testimony of Dr. Bloomfield?
But I don't think the testimony of Dr. Bloomfield has any relevance in this case. It might be an issue if we were talking about Mr. Pascazzi's, his capacity at the time he executed an arbitration agreement. We would have been arguing over that, all day long if he had been the one that signed here. His testimony is ultimately irrelevant, though, because Mr. Pascazzi didn't sign the arbitration agreement here because he lacked the capacity. Ms. Outwater.
Mr. Valdez, let me ask a question that's related to what Judge Sleet asked, but a little differently. If we were to reverse, what would we need to say about the portion of the statute that says that a person who in good faith accepts a power of attorney that appears to be executed in the manner required by law, can it be a good faith acceptance if the testimony is essentially, we took a piece of paper, but nobody reviews it?
Your Honor, I think that that wording is obviously wording that I think is difficult, but I think there's acceptance here because the facility, Ms. Outwater testified, if the person's incompetent, they look to the person that holds the power of attorney. Here, she accepted that power of attorney. It was included in the record. Ms. Outwater signed as power of attorney pursuant to that document. So she presented it. The facility accepted it. The record is a little unclear as to whether she reviewed it or not. It says they didn't have a specific person designated to review this here, but she's saying if you have an incapacitated person, you look to the DPOA because you don't want to get into the issue that arose in the cases that Judge Sleet was talking about. You don't want to get into a fight over the resident's capacity.
And that's why. Again, take about 15 seconds to wrap up, please.
Your Honors, Osprey appropriately relied on what appeared to be a facially valid power of attorney that was presented by Ms. Outwater in this case. Opposing counsel gave no factual basis that would establish that the facility was on notice of the supposed invalidity of this agreement. As a result, based on the language of the statute, based on principles of equity, based on the public policy that Judge Kelly was expounding upon, the trial court's decision here was just wrong, and it needs to be reversed. And we'd ask that the court do that.
Very good.
Thank you all for your time.
Thank you, Mr. Valdez, Ms. Tanaka. We have a 10-minute break.
And Judge Sleet, sorry, I ran over you there. Did not mean to interrupt.
Not at all, sir. Zoom is very difficult. We really hope we can get back to face-to-face. You did a fine job, sir.
Thank you all.